Welcome to day 3 of the International Men's Day celebration, brought to you by Heritage Bank. Now, we started this conversation on Monday, where our thought was led to securing tomorrow through finance and investment. And you will agree with me that it was a call to action. Also, yesterday, we were able to switch the conversation to another area completely, which is talking about your health, and also debunking the claims that as a man, you're supposed to pull out the strong outlook. You're not supposed to show your weakness. You're not supposed to even talk about it when you are sick, because you will be perceived as being weak. Yesterday, we were made to understand that health is wealth. You can only be around to take care of your family or of yourself or of the people depending on you if you are healthy. And we also were able to understand that it is not a misnomer if you go for your medical checkup. Today, we'll be talking about another sacrosanct area of our life. It is quite important that we have an idea and we have the knowledge and information, especially in this area, and that is estate planning and housekeeping. Now, you will say that with people from this part of the world, we believe that when we're having this kind of discussion, you are beckoning on death or you are preparing to die. Absolutely not. In fact, a good man will leave good inheritance for the people coming behind. We'll plan for the people coming behind. We'll plan for those who are depending on him. Now, when you're starting up your company, what are the right things to put in place? What are the right documentation? So that when you are gone, these things won't be a problem. It is not true that if you are doing housekeeping or estate planning, you will die in the next few seconds. Although nobody is assured of tomorrow, but putting things in the right order will even save you stress. We save the people that are depending on you stress after you must have gone. So this, you will agree with me, that is relevant and is important that we know. And just in this conversation is Elvis Asia. Elvis is the managing partner and founder of Law Future Partners, popularly called LFP. LFP is a full-service law firm in Nigeria and a consultant at Judge Etomi and Partners. Prior to establishing LFP, Elvis was a senior counsel at Nigeria's foremost law firm, Chief Rotimi Williams Chamber, where he practiced for over 10 years. He has over 12 years experience in estate planning, energy, finance, tax, entertainment, employment, and commercial dispute resolution related practices. Elvis graduated from the Ambrose Ali University in 2007 and was called to the bar in 2008, where he was a recipient of the Justice Olujide Shomolu Prize for Civil Procedure Law. He obtained a master's degree from the University of Lagos in 2014. He is a member of the Chartered Institute of Arbitrators, United Kingdom, the Institute of Chartered Secretaries and Administrators of Nigeria, and the Chartered Institute of Taxation of Nigeria. Elvis is a versatile legal researcher and a writer. He is the author of the book Oil and Gas Insurance and Nigeria Local Content Policy. He has published several articles on diverse areas of Nigerian law. You will agree with me that Elvis comes with wealth of experience and is able to give us the information that is required as we speak on this topic, housekeeping and estate planning. At this time, I'd like to welcome Elvis, and Elvis will be taking us through this conversation for about 30 to 45 minutes. Please note that the Q&A tab is opened so that you can ask your question, you can push your questions to us. I will be sure to get these questions to Elvis. Also, we are tweeting live. Follow us at Heritage Bank PLC. Push your question to us. Tag us with this question so that we can also push it to Elvis, where answers will be provided. At this time, I'd like to hand over to Elvis. Elvis, you've got the floor now. You're welcome.
Good morning, everyone. Thank you, Olabi, for that introduction. Thank you for joining us on the program. Today, my task is simply to do a highlight of estate planning strategies that as men we can adopt to plan the good life for our loved ones and family in the event of incapacity or death. I can understand that most people wouldn't like to talk about this because it's almost like Olabi said, you're inviting death when you talk about planning for the future. But estate planning is beyond actually planning for death. It's a realistic assessment of your state of affairs, and very veritable tool to ensure that your dependents and loved ones are not do not go through stress when you are unable to physically provide for them. And it's just like an insurance. If you insure your car or your vehicle against a particular risk, it doesn't mean you are inviting that risk to occur. It's just an assurance that when you are not there, there will be your children, your wife, and family will be well taken care of. Now, what is estate planning? Estate planning simply Mr. Wolowe, can you share the slide? It appears it's not coming on quickly from our end.
Okay, we'll do that shortly.
Okay, while we wait for the slide to be shared, let me just say that estate planning essentially has to do with the process, of arranging for the management and disposal of the person's estate, either during the person's life or in the event of incapacitation or death. The goal essentially is the effective management and preservation of your assets, either during your lifetime or in the event of incapacitation, as well as making the decisions on how your assets will be distributed or managed upon death. Statistics shows that we really don't think too much about estate planning. In fact, even in the United States of America, the African American community, it is estimated that over 70% of the population of the African American community do not even have any estate planning mechanism in place. And I'm sure the figures may be higher in Nigeria, given that we don't have realistic figures on these issues. And the reasons are very clear. I've mentioned the fact that most people wouldn't want to talk about debt. They don't want to imagine that there will ever be a time when they will be unable to make things happen for their family. Some people also think that you have to be extremely wealthy to put in place estate planning mechanisms. But these reasons are actually not correct because, like I said, an estate plan is a realistic plan to assure the future for your loved ones. And yes, whilst it is okay not to want to imagine your death, the fact is that this is a reality, that there's a certain end that will definitely come. So it's important for one to have that in place to protect family members in the event of that. Now, why do you need an estate plan? There are so many reasons why it is important to have an estate plan. Please move to the next slide, please. So many reasons why you need to have an estate plan. The first one is that certainty. You want to be sure that you want to ensure that your assets will be distributed or managed in the way and manner you actually want it. It will go to the people you actually want it to get to, and there will be no doubt as to how you want your assets and to be managed in your absence. So that is one of the key reasons why it's important for you to have an estate plan. Please go back a little bit. Please go back to the. Okay. Now, of course, the welfare of loved ones is also very key. with the energy and the fact that you are there right now, you are providing for the family, you are taking care of your children's education, health, and other important things that they need. But what happens when you are not there? We have seen cases. I recently had to assist a lady whose husband passed on, and for months they couldn't afford to pay school fees. Just after a year, and yeah, the man left quite a lot. But because of the stressful process of getting those assets to be meaningful for them, they couldn't pay school fees, and some of the children had to drop out of school. So you want to avoid that. So you want to ensure that in the event of incapacitation or death, your loved ones will not have to go through that kind of stress. And of course, in Africa and in Nigeria, and a very important reason why estate planning is very essential is the various cultural practices across the country. We live in a country where despite the modest gains that the courts have made in an attempt to strike down a lot of the cultural practices across the country, women are still seriously disadvantaged. We still have places where the moment the man passes on, family members will pounce on those assets in an attempt to deny the wife and daughters of the inheritance. This is a very common thing from the eastern part of the country and across the country. And so you want to avoid that. You don't want a situation where your children, particularly your minor children and your wife, to be at the mercy, of family members whose interests obviously may not be to protect what you love, what you hold dear in your lifetime. So it's important to avoid these cultural practices and make certain that they will not be the default rules that will be applied to your estate. To the disadvantage of your wife and children, particularly your daughters. And another thing is that you want to prevent family disputes, family feuds. I have been involved in a case since 2010 with respect to a vast estate, of children, who have been fighting over the estate of their father. And one of the reasons why this is happening, in my view, is that there wasn't any definitive proper arrangements of the estate during the lifetime of the deceased person. So, and we have cases from the High Court, to the Court of Appeal, to the Federal High Court, to the Supreme Court. All of these cases, 10, 20 cases over an estate. But if you put in place a proper estate planning mechanism during your lifetime, the chances are that these disputes will be substantially reduced, and everybody will be happy, because it's beyond just properties and assets. When you don't tame the possibility of disputes, the chances are that your family members will be disunited when you're not there. They'll be fighting amongst themselves, and that's not something you want to. That's not a legacy you want to leave behind. So you want to tidy up to ensure that that is not the case. And of course, easier and timely access to assets. It's very easy to have access to assets when, what I will, in a short while, I'll talk about some of the mechanisms that are available for you to explore. Some of them, it's even during your lifetime, you can actually put it in place. It can even protect you and your loved ones during your lifetime. And then when you're not there, it will be very clear and easy. So it's not like a situation where if you die without leaving an estate plan, what will happen is that it will mean you died intestate. That is, you die without leaving a will or leaving an estate plan in place, and default rules will be applied. And the first thing is that you have to go and get probate. I'm sure in the banking industry, Heritage Bank is organizing this, and I'm sure a lot of the staff are part of this. You will see that sometimes people will have monies in their accounts and they are unable to access it because you're going to ask them to go and get letters of administration. And in Nigeria, that can take forever. I have been processing one letter of administration for over a year now. With coronavirus and everything, the families, they are in extreme difficulty. And so you want to avoid that by having in place a system that makes it very easy and timely for them to have access to your wealth when you are not there. And if you don't have an estate plan in place, one of the risks is that your family members may not even know the whereabouts of your assets. There was a case of, again, a lady whose husband left 10 million naira in an account that she was not aware of at all. What saved her was somebody came from the UK, a friend of her husband. They had done the business together where they got that money, and they both had the accounts together. And the man was very nice. And when he came to Nigeria to visit, on a condolence visit to the lady, and he told her, look, do you know that your husband have so and so in so and so bank? She said, no, she didn't know about it. We had to write to the bank. Of course, the bank wouldn't want to listen to you. You have to go and get a letter of administration. All of this you can avoid, if you put in place a good estate plan. Then, of course, reduction in cost. It's very costly to obtain probate. It's very costly to obtain letters of administration. Whilst, yes, wills and it can be an effective means of estate planning, but there are also other mechanisms you can use. So it reduces cost. There are also tax advantages which you can benefit from. Now, what are the estate planning options that you have? There are so many estate planning options. I'm sure a lot of people will be surprised to see that marriage can be an estate planning mechanism. Don't be surprised. This has been the case from generation to generation. If you take historically in places like England, marriage was an estate planning mechanism. It was a plan by the man to take over the estate, maybe if the woman is from a very rich family and all of that. So it has always been the case. And currently under our law, if you are married under the Act, if you conducted a statutory marriage, in the event of death, your estate is shared in a way and manner as to give priority to your wife and children. Okay, there will be no place for customary rules on inheritance. Your wife, for example, will get 1/3 of the real estate. She will get all the personal properties, and this is already part of the law, and the children will share equally in accordance with the law. It's only when you don't have a wife or you don't have children that it can pass on to, the way the law defines who gets what and next. So it's important to ensure that you tidy all your affairs. If you've been married under customary law, you want to, approach a marriage registry to concretize it. I'm not saying that customary marriage is less value, but if you want to protect your wife and your children, you want to explore that option. Another option you can adopt is joint ownership of property. Rather than waiting to get probate or letters of administration or rather than waiting for a will, the best way and the very cost-effective way to pass properties to the next generation is to jointly own it. You can jointly own a landed property with your wife, your children. You can have a joint account with your wife. The law is that in the event of your death, on the principle of survivorship, the property automatically passes to the next joint owner. So you don't need to obtain any documents. You don't need to go and change title, right? All of those costs, you're going to save it. You don't need to go and obtain probate to get the money. The woman already have access to the account. When I had this kind of discussion with somebody, and the person was telling me, "Oh, what if you have a bad wife and she goes and take the money while you are still alive?" And I'm like, well, I don't want to go into those kind of sentimental talks, but what is important is that there are ways you can also check it. You can say, for example, if you have a joint account with your wife, you can say, "Oh, she can only withdraw up to certain limit." That can check it. And in these days of alerts, it's very difficult for somebody to just go and take all the money without your knowledge. And so it's important for you to have a joint ownership of property. You can do it now. When you're acquiring properties, acquire it jointly with your wife, with your children. You can, like I said, hold joint accounts with your wife and children. That is a very important means of estate planning, and it will save you a whole lot of stress and costs, in the event of the unthinkable. Okay. Another strategy option you can adopt, is life insurance policy. This is a very, I'm sure somebody must have talked about this as an investment tool, not just, not just for you, but for your children, for your wife. You can have an insurance policy, a life insurance policy, and, in the event of the unthinkable, your dependents will be able to access it and use it, to continue to live the kind of lifestyle that you left for them. The good thing about this is that it's a very strategic tax management tool, because your life insurance policy, the premium that you pay for life insurance policy is not subject to tax. Okay, so you can actually use it as a way to avoid paying tax. Rather than paying tax to the government, why don't you save that money for the future, for for the family members to take it? It's a legal means of avoiding tax, and I'm sure it's something that is worth considering. You can also explore the pension option. Currently, your employers are under obligation to, make contribution. You also do contribution, or you can also do voluntary contribution. The idea is that, just imagine saving 20,000 naira a month or 30,000 naira a month for 30 years, for 20 years. In your absence, that will be a lot of money to solve a lot of problems for family members. Now, another system you can adopt is the option of a deed of gift. Okay, a deed of gift. Whilst you are still alive, you can transfer your property to whoever you want it to go to, your children, your wife, or any other cause for which you want your property to go to. You can transfer it, and the good thing about that is that the property would have passed during your lifetime. It will not be subject to will. It will not be subject to the probate process that can be laborious and difficult and costly. Okay, but though the only issue is that because it's a transfer, the law would require that you obtain the consent of the governor to do so. But just having the deed of transfer itself, even with or without the consent, it's something that protects whoever you have assigned the property to. Because yes, whilst it may not be admissible because you have not obtained governor's consent, the good thing is that it's still admissible to show that you have transferred the property. It will form part of the estate in the event of death. So it's important for us to explore the option of gifts. I mean, if you give to your family members whilst you're there won't be any disputes in the future. Okay, another way you can set up an estate plan is to create trust. Okay, for a trust is simply a system where you appoint a third party or third parties to manage your assets or for the benefit of your dependents and loved ones. You, as the settlor, as the person who owns the property, you transfer it to a third party. The third party can be your friend, can be somebody you consider trustworthy. If the asset is complex and you want professional management, you can get a trust company, and then you appoint them. You transfer the property to them. They will managing it. Trust is very good for for taking care of your minor children. Okay, if your children are too young to have to manage the size of the access that you have, or you have a business that they won't be able to manage when you're not there, you can create trust, and the trustees, as the people you have appointed, will be managing the properties for the benefit of your children. There will be what's called a trust deed. That trust deed will set out in very clear terms what they can do with the assets and who they're going to pay to, in what proportion, and all of that. So that is also a veritable tool for estate management. Another thing you can do is you can set up a company. Rather than owning properties in your name, you can set up a company. You can call it whatever. You're a shareholder, your wife is a shareholder, your children are shareholders, whoever you want to be beneficiaries of your estate is a shareholder of the company, and your assets are owned by the company. So if you are not there, the company continues. there will be no need to change title. There will be no need to obtain probate or letter of administration. It's only with respect to your own shareholding in the company. And you can, of course, have an arrangement to ensure that your own shareholding passes to whoever you wish it to pass to, during your lifetime. This is a very good system of estate planning. It doesn't really, some people will say, oh, I don't have enough yet, but you don't have to have enough yet before you can do this. You can create an investment company. It's very easy to register companies these days with the ease of doing business system that's going on at the Corporate Affairs Commission. And you can even register it by yourself now online. So you have that company, you acquire your assets in the name of the company, and your children, your wife are shareholders, and so they can always take the benefit of the assets using the company. So that's one way to have an estate plan. The most common way people plan their estate is to create a will. A will is a document which contains all the deceased person's wishes with respect to his estate, to include things like what is the property, identify the property, who gets the property, in what proportion, and then who will be the executors, that is those who will be charged with the duty of ensuring that the property passes to the beneficiaries of the estate. They are identified in the will. The good thing about a will is that, of course, it will obviate the need for the application of default rules on inheritance. You avoid customary law inheritance practices to avoid default rules, and you can specifically give out whatever you want to give somebody. You can even give out your assets to protect causes that you believe in. Ordinarily, that nobody would. There are no default rules to ensure that your estate protects any cause that you wish to protect. So, but if you have a will, you can actually indicate in the will the cause you wish to protect and the fund from which you want the protection to come from. So you can put all of that in the will. You can also state how you want how you want to be buried, and all of that in the will. So will is a very veritable tool. But of course, you know that for a will, you still have to obtain probate. Your family members will still have to obtain probate. But it's better than not having it, because once the will is there, most people will be confident to deal with your beneficiaries and the executors with respect to taking the benefits of the assets. Another thing you can also do is you can create a power of attorney. Power of attorney is simply a document by which you authorize a third party to do whatever it is you have listed in it on your behalf. It can be, for example, to manage an account, to manage real estate property for the benefit of your minor children, and so you can have that in place. You can authorize a lawyer, a professional, or any person, maybe even a family member, to manage the assets for the benefit of your loved ones. So power of attorney is also very good and something you can consider exploring. There are a few important things that you need to consider when you talk about estate planning. Of course, first you have to establish the value of your estate. What is the value of your estate? You have to take stock. Okay, most people don't know how much they have until they sit down to really put it together. Today, it's very easy. You can buy real estate mentally in different places. They may look far now, but 20 years time, your children will be happy that you have them. Even if you buy a property for 500,000 naira now in a very far location, but I can assure you that 20 years from now, it will be of value. So that's something you can count as part of the things you want to pass on to the next generation. So it's important to take stock of the estate. Another thing you need to also do is to determine who you're going to appoint. Who do you want to manage your estate when you're not there? Who will be your what we call executors. Executors are people you are going to name in your will to manage your estate and pass it on to the beneficiaries, okay? Or trustees. Trustees will be people you have appointed under a trust deed to, and you have transferred your assets to manage for the benefit of your family and loved ones. You also want to think about who will be the guardians of your young children, okay? Your young members of the family. This is very important because you want to be sure that you have somebody that's trustworthy, somebody that has the time to dedicate to doing what you want them to do, somebody that has the expertise to manage what you want them to manage, and of course somebody, I've already mentioned somebody that's trustworthy. You can't emphasize that enough. I mean, you have friends and family members. You can, at least from past relationship with them, you can determine whether or not they are worth it. You don't want somebody that would eventually convert their assets to their own when your children are still very young. So you want to make sure, and then you must make sure that it's a clear deed that is executed and it's not shrouded in, it's not hidden. Your children are well fed. Some other family members are well fed to avoid a situation where there's a conversion. We have seen situations like that. So it's important to really be very careful with who you appoint. People prefer to appoint professionals these days, but that comes at the cost, and that should only be explored if the asset is such that can take care of the professional. The professional can pay up the professional cost and all of that. Then you want to think about when should you have this plan. The best time to have the plan is now. Nobody knows tomorrow. In a society where life expectancy is quite abysmally low, and the fact that people are being incapacitated and dying on a daily basis, there's no better time than now to have this plan in place. And what mechanism should you adopt to transfer your wealth, or to what estate planning mechanism should you adopt? Of course, that depends on the nature of the assets. Cash flow. I mean, do you want to tie down the asset now that you're still alive, or you want a situation where you can still have access to it whilst you're still alive, and then there's a mechanism where it passes to the beneficiaries when you're not there? So that would determine the kind of system that you are going to use, and of course that would mean that you have to sit down with a professional and we will take stock, look at your assets, and advise on the appropriate mechanism that you should adopt. Of course, you also need to think about the future needs of the beneficiaries. For example, if you are thinking about a life insurance policy, you're thinking about, okay, if I put this in place, maybe for 10 years, for 30 years, for what milestone will my son or my child be going through at that time? You want to target it. Or is it to pay for college, to pay for university, to pay tuition, is it for medicals? So you can have an investment, for example, that targets that, and you have a trust system that manages it, for that purpose. So it depends. So you have to look at the future benefit, what the age of your children, what your wife does. All of that can count in determining the estate planning mechanism you adopt. But like I said, it's important it's when the stock is taken of what you have with a professional that can easily be done. In conclusion, of course, the definition of a life well spent cannot be complete without the final word on the management of your legacy. No man can truly love his family without ensuring their comfort in his absence. With the high rates of disputes over estates, the difficulties of assessing properties left behind, and the high cost of securing inheritance in Nigeria. It's important for every man to become future forward by taking deliberate steps to put in place a plan to manage and transfer assets in the event of incapacity and death. Thank you for listening. I will now be ready to take the questions.
Thank you so much, Elvis.
Thank you.
And the first question that I would like to I am ready to do my estate planning through will, and it's done already. But today I feel happy. I'm seeing my person doing well, and I like to will over I like to give him everything because I know that he can take care of it. But then tomorrow I see that there are some things that are wrong, and then I'm not so sure again. How often can I change my will?
Well, there's no time limit on how often you can change your will. You can always change your will by having what they call codicil. You can have a subsequent will anytime there is a drastic change in your status, either financially, marriage-wise, having kids. So anytime you have any major change in your financial affairs or your status as a person, you're free to change and amend your will.
Okay, so it doesn't matter. I can continue changing as long as I want.
Yeah, you just have to ensure that you, in whatever change, any new will, you either say expressly that you have cancelled all previous wills, and so this is the current one, so that there will be no dispute in the future as to which one is the current one. So it's important for you to state clearly what you are doing. If you want to add, maybe there's a new property or new assets you want to add, then you can do a codicil. But if you want to change the whole general framework of the will, then it's important for you to revoke the previous ones, and you have to do so in clear terms, so as to avoid a situation where there will be competition as to which one is valid when you are not there.
Okay, thank you very much. We know that many of our people that are trying to log in are having network challenges. So if that be the case for you, be rest assured that this conversation will be available on YouTube at the end of the session, so you can watch the video from the beginning. And also on the same platform, we'll leave it open for about 30 minutes after the conclusion of the conversation, so that you can press the blue button, and you can as well rewind so that you can have this conversation and ask us questions on our social media platform. Moving on, Elvis, now you talk about joint ownership, and is there a way you can customize it to so that this thing should not be activated until the demise of one of the partners or the leading partner? Is there a way you can customize the clauses in there?
No, if you are a joint owner, then you have to be the owner. I mean, you can't postpone ownership. So joint ownership has to be effective from the day it is done. But like I said, when it comes to properties, maybe real estate, if you're a joint owner, you can't determine, you can't say, oh, the joint ownership will, that is something you can do in a will. But if you just want to jointly own property with somebody, it has to be effective immediately. For joint accounts, it's the same. The only good thing about joint account is that you can limit what the other person can take out of it to the mandate that is given to the bank. Okay? But for real estate, joint ownership has to be effective immediately. If you want to postpone ownership in favor of somebody, then you have to either do a trust or you do a will.
Thank you. So as a professional in this field, you have talked about different types of estate planning options. Now I'm considering one. Which one would you recommend? Is it deed? Is it will? Is it power of attorney? Which one would you recommend?
Well, nobody can say that one is better than the other. It depends on the facts and circumstances. One will have to, for example, interview you and to see what your assets are, your station in life, and the people you want to pass it on to. Like I said, some of those considerations, like what is the cash flow issue that is involved, either for you or for the beneficiary. So it's difficult to say that one particular option is the best. In practice, you probably need to do a combination of the options, to have the best outcome.
Thank you, Elvis. So, is there a rule that is binding the legal professionals that when I have my will, we know that it's supposed to be read after the demise of the will owner? Now, is there something binding legal practitioners to be able to account for everything that is written in the rule so that it will not be tampered with after I'm gone?
Yes, a legal practitioner is subject to the rules of professional conduct. And the rules of professional conduct is quite strict. It builds on a legal practitioner to ensure that the will of a deceased person or whatever estate planning mechanism that he's aware of that the deceased person has put in place is properly is given effect in the event of death of the person. So there's the rules of professional conduct that binds a legal practitioner. And like I always tell people, and it's simply because in this part of the world we have not been activating it. If you engage a professional, whether a lawyer or any professional to do anything, if there has been a misconduct, apart from the professional discipline that comes with the rules of professional conduct, the person can be held liable by whoever suffers from that. So it's important that lawyers know that. So there's the rules of professional conduct that binds a lawyer. I can tell you for free that it's not going to be an easy thing for a lawyer to want to subvert the will of your will. But there are ways you can checkmate a legal practitioner. Once your will is done, make sure it is deposited at the probate registry. Okay, make sure it is deposited. Now, once it is deposited, make sure you get a certified true copy of it, of the deposit of your probate at the probate registry. And so, with that, you can have it somewhere your family members can access, so that if they bring something inconsistent, you will be able to they will be able to challenge it. So that's one way to do it. But apart from rules of professional conduct, like I said, a lawyer can be sued for even negligence or misconduct with respect to the management of the estate. And the person, as part of protecting the future, must ensure that the will is lodged at the probate registry, and you have a certified copy from the probate registry.
Thank you very much. So moving on to one of our questions, for your landed asset. Now, especially in Lagos, where you have a case of Omonile coming to lay claims on your land, the land that you think it's yours. And since the landowner, has gone, it's part of your will and it has been willed to someone else, and there is a lot of back and forth. It's becoming like a rancor between those who claim they own the land and the people you have willed it to. How do we ensure that after you have gone, the landed asset is still yours and it can be passed on from you, the owner, to the people you have willed it to?
Well, there's many things you can do to ensure that your landed property gets to your intended beneficiary. And one of the things you can do is that when you acquire property, make sure that the title documentation is properly in place. Make sure that there's a contract of sale, there's an agreement, there's an assignment given to you, and that it is registered. Okay, so you must make sure that the documentation process is perfect whilst you are still here, so that once there is a public registration of a title with respect to the land, that gives some form of security to whoever is going to get it thereafter. Another thing you can do is that you ensure that when you're buying property, I advise people now, try and buy from, a well-planned area, like a well-planned, maybe like all these estates in different areas, rather than just buying in a lonely place where there's, where the land is largely controlled by the moniles. So if you buy from an estate management company that has title over a vast area, the chances that the land will be secured will be higher. So you have to do that, and then also make sure that your family members are aware of your properties, because some people buy land in so many places and their family members are not aware. They've never been there. They don't even know the location. So it's very easy for any of Molile to take it. Another thing is that also make sure that once you buy property, there's some form of development on the property. Because sometimes some of these communities, when they give you agreements or receipts, they always indicate that if you don't develop it within 2 years, within 3 years, that you may have to pay additional money or something. I have a case like that now, where there was a contract of sale that they had with the community, and the community says if you don't develop the property within 2 years, the property will revert back to the community. So you want to avoid situations like that. Try to make sure that there's some form of development. You can put in a fence, you can, put in something, a structure, no matter how small it is, to ensure that the moniles are pushed away. But the good thing in Lagos now is that these days there's a law, there's a system that that checks the monile practice to a very large extent. So just make sure that your family members are aware of the property, make sure the title is properly documented, and make sure you're buying from the right sources, okay? And then make sure you buy from a planned area rather than just buying from any strange place.
Thank you. Moving on, one of our participants would like to know the difference between deed of gift and power of attorney. Can you shed more light on those two?
Okay, deed of gift is simply it's a document that gives title, that vests complete title on you. So if I gift my land to you, it means it becomes yours immediately. That deed is executed and the property is physically handed over to you. Okay, so deed of gift gives you title. It's almost like it's similar to a sale. It's just that in this case, there's no consideration for it. Okay, so you have complete title over the property the moment it's given to you. But for a power of attorney is just a management tool. You are empowering somebody to manage the property on, for your beneficiaries. So it doesn't give title to the person. The person doesn't own the property. Okay, the person used to own the property. The only difference now is that the person is the one managing the property. So the big difference is in title to the property.
Okay, thank you. Another question is, for a man that divorced his wife, what becomes of his will?
Well, it depends on what you have in the will. If in a will you can give anything to anybody in your will. So if you divorce your wife and you don't change your will, the will is still effective. Whoever the divorced wife will still be entitled to whatever was given to her under the will. So if there has been a divorce and you don't want the wife to get what you originally gave to the person, then you have to change the will. If you don't change the will, then it doesn't affect the validity of the will, because you can give. There's nothing stopping you from giving assets to anybody under the will.
Thank you, Elvis. Again, we understand that some of the people that would like to connect with us on this, to have their own voice heard on this conversation, are having network issues, and it is understandable. But again, we want to tell you that this video will be available on the bank's YouTube channel. Just subscribe, like the video, view the video, and when you have a question, please tag us on Twitter or send it to us directly via email, and we'll be sure to contact Elvis, where we'll provide answers to your question. At this point, Elvis, we want to say thank you for speaking with us and for sharing, for shedding so much light especially when it comes to this conversation. So we have one more question, and the question is, how will your beneficiaries inform the trustees or the executor of your demise in case of non-disclosure? Let's say you didn't inform them of your will anywhere.
Well, first, it's important for you to ensure that if you are appointing anybody as a trustee, of course, you can't appoint somebody as a trustee of a trust without the person knowing it, because it will be an executed trust deed which the person will have to sign. So for trust, the person will be aware. Yes, it's possible that for a will, the person may not have informed the person who he or she is appointing as an executor. I think it's important for you to let people know that you may be considering appointing them as executors. But in the event that they're not aware that they were appointed, if I get the question correctly, if they're not aware that they were executors of the will, once the will is read, the executors will be mentioned expressly. So if, for example, the will is lodged at the probate and the lawyer brings it out, gets it out and it's read, or you apply to probate yourself to have the will read, once it's read, the executors will be disclosed and they will now be informed, of their duties under the will, and they will have to then take steps to enforce and give effect to the will. So the process of reading the will, it's apart from informing the family members of what they are getting out of the will, it also discloses who the executors are.
Okay, thank you. What happens immediately after getting an administration letter? I mean, after presenting to the same bank, what procedures are to be taken to retrieve funds from a deceased family member's account?
Well, the first thing is you obtain letters of administration. But before you obtain letters of administration, once you apply for the probate forms, the relevant forms, there's at some point to be taken to the bank, and the bank will indicate whatever amount is there and all that. Then when the letters are obtained, you have a copy on the bank, and the bank will have to give effect to the letter of administration. Once they confirm the validity of the letter of administration, they would not have any choice but to confirm it. So the process is simply obtain the letter of administration and then write to the bank attaching a certified copy from the probate registry, and they will act on the certified copy from the probate registry.
Thank you very much. So Elvis would like to know, is there a difference between living will and will? Is there a difference?
Well, people use that term mostly when outside of the country, when they talk about living will or not living will. Because here under our law, a will is a will, and the law clearly defines what the will should contain. When you say living will, I would think that can only be with respect to a trust, which, for example, you can have even during your lifetime, and it can also protect your assets when you're no longer there. But typically, having a will, you simply give instruction on what happens to your assets, who gets what, who the executors will be, and all of that. So, that term, it's really not very significant under the Nigerian legal system. Yes, I've seen that in some other places you can talk about living will or not, because the will is ambulatory. It can only speak after you're dead. There's no room for a will to be giving effect to when you're still alive.
Thank you, Barrister.
So, legal trust.
Okay, moving on, I have a question here. If I make my wife a signatory to my account, and in the event of death, is she protected, or will she have to go through probate for letter of administration to access the fund in the account?
If someone is a joint account holder, the law is that the law applies the principle of survivorship. What that means is that since it's a joint account, whoever is alive, is entitled to whatever is left of the account. Then we don't need for you to get letter of administration. I know that it's possible in Nigeria to have some banks insisting that you have to go and bring letter of administration for the deceased joint holder. In law, the principle of survivorship is what applies. Whoever survives is entitled to whatever is in the account, and there should ordinarily be no need for any other legal process to assess the account. But like I said, it's possible in Nigeria to have some banks insisting on getting letter of administration, but I'm sure if they are challenged, legally speaking, that practice may not succeed, because that the principle of survivorship, it's what the law applies.
Thank you, Barrister. So moving on to our last questions. The questions keep on dropping because now we have people connected to us. So is all those receipts issued by communal clan when they sell landed property to you, are they legally binding? Isn't it just a plain designed and graphicated ordinary paper?
Well, they have legal significance. A receipt with the name of the person selling to you, the purchaser, the amount that is the purchase price. It's almost like a contract of sale. Okay, so it has legal significance. It's evidence that you have paid for the property. And in law, the moment you have paid for property, you obtain what is called an equitable interest in the property. So that interest, coupled with possession, is almost 99% of ownership. Okay, but yes, to really make it legal, you have to obtain other relevant documents. For example, you have to get an assignment, and it has to be registered with the consent of the governor. But that doesn't mean that if you have a receipt or a contract of sale, that you don't have interest in the property, because it gives you the receipt and possession gives you 99% of ownership. What you now need to do is to concretize this legally, because if there's somebody else that has interest, the challenge you're going to have with receipts and contract of sale is that, assuming they sold somebody else before you, okay, that may affect your own title or your interest in the property, which is why it's best to have a legal documentation, which is a deed of assignment that is registered and in respect of which the consent of governor has been obtained. So, when there's a competition between two receipts, for example, or two contracts of sale, the first in time will prevail. Okay, and in most cases, the person who has possession may have the upper hand, because in Nigeria, given the legal system, it takes almost forever to get anything out of the court system. So the person in possession may have a better interest, or have upper hand with respect to the property. So the receipt does not give you full security, but it gives you substantial security with respect to property if it's coupled with possession. So it's not a worthless paper, but it's better to have legal documentation.
Thank you so much, Barrister. It's been an engaging conversation, and it's an eye-opener, quite informative, and also helping us to understand the things that we are supposed to note, especially about this sensitive discussion. Now, you can say that we have started with securing your tomorrow by investing. We have also talked about your health as being very important. Today we have talked about housekeeping and estate planning. Now the question that you can be asking yourself is, what next? How do I proceed? What am I supposed to do? Now, be sure that you're not alone in this conversation. Be sure that you're not alone asking this question. Now, tomorrow we are bringing somebody on board, a resource person that comes with a lot of experience to share with us. about his humble upbringing and how he got to where he has gotten to. About the fact that he has taken into consideration all these our conversation and has taken practical steps to ensuring that these things are done and they have gotten him to where he is. Tomorrow, by the same time, we'll be bringing on Dr. Larry Samuje, the CEO of Brilla. As popularly known, he will tell us his own story. He will tell us the practical principles he has applied and how he's able to get to where he is. The truth of the matter is that if we as men learn from one another, we will make this world a better and safer place. If we are able to learn and follow the principles that have worked for others, it will not be shocking or will not be surprising if we also are able to get to where great men of old have gotten to. Once again, Barrister Elvis, thank you so much for sharing your thought with us. Thank you for taking this time to be with us. And so tomorrow, I look forward to seeing you. I look forward to having this conversation with you. Be rest assured that the conversation will be fruitful. Be rest assured that the conversation will be engaging. Please come with your questions. Real life, we're going to be going practical this time around, real life scenario. We'll be talking about life principles. We'll be talking about charting the course, making the way. How do you go from here? How do you move from here? To join our conversation, please follow our social media handles on Facebook, on Twitter, on Instagram, as well as YouTube, all of which are at Heritage Bank PLC. Once again, don't forget that if you miss this video, if you miss this webinar because of network issues, you can always catch up with us. Just go to our YouTube platform. You will see this video there later in the day. And put your comments underneath, put your questions there. There'll be somebody readily available to answer your question. Once again, from us at Heritage Bank, we hope that you will keep on staying safe. And also, we hope that you will not give up wherever you are. You will continue to stay motivated and you will continue to beat the others. Once again, we want you to enjoy the rest of your day and please stay safe. Till I see you tomorrow, stay safe and be the best you can be. Bye for now.